Thank you, Mr.
Yes.
Yes,
You're just relying upon this one decision.
No, other points are there. Marmal will rely on that because the troubling factor which I can read.
no, the other judgments are on what
The other judgment are, my lord, the points has been given. Unequal distribution. There are two judgments I have given. My lord, signature of the testator, how to be made. Those judgments are given. Delay. And this is the point of delay, which is not a bar.
Section 90 presumption.
And presumption, my lord, that is also there. So I have
1953 Calcutta.
নিয়ে চলে গেলে মুশকিল হবে।
Turn to my lord, page 92 of the paper book. Page 92 of the paper book, your lordship, last paragraph. The petitioner Kartik Lal Sahu filed a petition for probate of the will in the year 1975. This is the first one in the court of the district delegate. That petition was registered as probate case number 64 of 75. It is further stated in the petition that there was a talk of compromise and as such the petitioner did not proceed with the said probate case. There is no other petition pending. My lord, I am reading from page 92 of the paper book.
Yes.
Main paper book. There is no other petition pending for probate or letters of administration of the will. So end of the matter with regard to the first probate application, 75. Then this present application was filed. This is the second application.
Not a continuation.
Not continued. Your lordship will find the last line shows there is no other petition pending the probate or letters of administration of the will. Then next page. That petition was registered as testamentary case number PP6 of 89. This is the second one. So, there is no confusion with regard to the first petition and the second petition. Right. Then, kindly turn to, I'm not going to have in my written notes, my lord, I have given the entire thing, what was contended, what I have contended, and what is the judgment relied on. Now, your lordship, in last judgment which I have placed before your lordship in my corrected written notes, which I filed today, kindly turn to the judgment delivered by, that has been annexed with the note. AIR 2023 Calcutta 267. Before Justice Somin Sen and Justice Uday Kumar.
Yes.
Now
Para?
kindly,
Para?
Madam giving it. Your lordship will, my learned friend cited this
Para
judgment,
30 onwards, you said.
Kunvarjit Singh versus Kanpur case, SCC.
Paragraph 15 আছে।
My lord, kindly turn to paragraph 14. That judgment was considered. Paragraph 14. Applying the ratio in Kerala ACB case, the court in Kunvarjit Singh observed that, then quoted, crucial expression in the petition is right to apply. In view of what has been stated by this court, Article 137 is clearly applicable.
Where you are reading? Para 14.
Para 14, yes.
Supreme Court in Converjit
Converjit
Sir,
Singh,
did
that
you-
is the judgment, my lord,
Yes, yes.
cited, relied on by my
that and held that
The crucial expression in the petition is right to apply. In view of what has been stated by this
we
court,
are not getting it, Mr. Ghosh.
my lord,
Crucial, we are not getting. Which paragraph
Yeah,
14 you are placing?
just a minute, man, let me check it up. Oh, I see. না, ভুল হচ্ছে আমারই বলা।
That must be in paragraph 30.
হ্যাঁ,
The Supreme Court in conversing para 14, 13, 14.
না।
Right. That's paragraph 34.
Yes, 37. Mal, kindly turn to 37.
34.
34 you are
34.
placing. 34.
4.
34.
Kunwarjit Singh referred to. Which you showed us in
In
page.
Kumarjit Singh, the Supreme Court explained the concept of right to apply for
Yes,
probation.
yes.
Yes, that's para 34.
Apart from the aforesaid applicant, I may skip it over, my lord. It has been discussed next also.
Para 37.
Paragraph 37. In Ramesh versus such and such,
ওইটাই কোট করেছে যেটা দেখো।
the Supreme Court reiterated that the Succession Act does not prescribe any specific period of limitation. No doubt about it. We also, my lord,
Where you are reading? Where you are? 37 you are reading.
that 37.
Place it in Ramesh Nivrutti.
In Ramesh Bhagavat versus Surendra Manohar, the Supreme Court reiterated that the Succession Act does not prescribe any specific period of limitation for the grant of probate or for making an application for revocation or cancellation of probate or letters of administration. The residuary Article 137 of the Limitation Act, which covers proceeding for which no period of limitation is stipulated in the Act, provided for 3-year period of limitation would govern such proceedings. In affirming the views expressed in Kunwarjit Singh case, the Supreme Court observed, that is the judgment which was cited by my lordship. It observed, then this issue was considered in Kunwarjit Singh versus Kirandeep Kaur. This court negated the plea that since the Act prescribes no period of limitation in regard to matters concerning grant of probate or letter of administration, there is no time limit. The court followed the decision in Kerala ACB versus TP Kunali, very difficult to pronounce, which took note of the change in the collocation of words in Article 137 compared with Article 181 of the Limitation Act 1908 and held that applications contemplated under Article 137 are not applications confined to the Civil Procedure Code. In the older Limitation Act of 1908, there was no division between application in specified cases and other applications as in the Limitation Act 1963. The court held in Kerala ICB case that the words any other application under 137 cannot be said on the principle of ecdem generis to be applications under the Code of Civil Procedure other than those mentioned in Part 1 of the third division. Any other application under Article 137 would be petition or any application under any act, but it has to be an application to a court for the reason that Section 4 and 5 of the 63 Limitation Act speak of expiry of prescribed period when court is closed and extension of prescribed period if applicant or the appellant satisfied the court that he had sufficient cause for not preparing the appeal or making the application during such period. Then the conclusion we reach is that Article 137, this is, my lord, the paragraph of that judgment.
Yes.
The conclusion we reach is that Article 137 will apply to any petition or application filed under any act to a civil court. With respect, we differ from the view taken by the two-judge bench of this court in Town Municipal Council versus Labour Court and hold that Article 137 of the 1963 Limitation Act is not confined to application contemplated by or under the Code of Civil Procedure. Applying the ratio in Kerala ACB case, the court in Kunwarjit Singh observed that the crucial expression in the petition is right to apply. In view of what has been stated by this court, Article 137 is clearly applicable to the petition for grant of letters of administration. As rightly observed by the High Court in such proceedings, the application merely seeks recognition from the court to perform a duty. Because of the nature of the proceedings, it is a continuing right. The court then concluded that the right to apply for probate accrues on the death of the testator. And my lord, their lordships, my lord, discuss the other judgments also.
So why you are placing reliance upon?
What that limitation? 137 applies.
Limitation Kunwarjit said no time limit is there. First, it is dependent upon the cause of action and the right to sue.
No.
Yes.
No.
Kindly come to page
Yes.
paragraph 34.
Yes.
Kindly cause it's a clause C you see.
Paragraph.
34.
Paragraph 34, those riders have been quoted which Mr. Basu placed.
Yes.
Under limitation and no period is advisedly prescribed within which an application for probate letters of administration succession must be made.
Yes. The assumption that under Article 137, the right to apply necessarily accrues on the date of the death of the deceased is unwarranted.
Because there is no time limit according to the Supreme Court.
This judgment has been negative by the Supreme Court itself.
Where do we find
My lord, kindly see these subsequent paragraphs.
that?
That's why, my lord, their lordships, Justice Sain, my lord, sitting with Justice Uday Kumar, my lord, delivered
Applying
this
ratio
held that
between
limitation applies.
No, you see paragraph 39, Mr. Ghosh.
My lord,
See paragraph 39.
yes,
Go through 39 once.
paragraph.
Keeps the entire thing open.
Yes, question of limitation arises only when there is any threat or challenge to the will, right? The grant of probate by a competent court operates as a judgment in rem, and once probate is granted, it binds the whole world, and it operates from the date of the grant. In a proceeding for revocation, the limitation period would commence from the date of the grant of probate and shall be governed by Article 137. The right to apply under Article 137 in the context of a probate would be the date on which the dispute arises or when it becomes necessary for grant of probate.
Filing an application for probate.
A party may also apply when a challenge is made to a will as manufactured, forged, and other things. There is no outer limit for filing the application for probate, and the time would commence from the date when the right to apply accrues. The right to apply under Article 137 for the purpose of limitation has to be contextual, and it would apply from the date on which the right to apply accrues, which is variable and would depend upon the facts of the case. It would vary from case to case. It is possible that the executor may not be aware of the death of the testator in every case. The date of death of the testator is not crucial or determinative of the right to apply for probate for the purpose of limitation. In any way, Section 293, probate or letters of administration with the will annex may be granted after the expiration of 7 days in case of probate and 14 days in case of letters of administration from the date of the testator. In Kanwarjit Singh, it appears that there was a probate petition filed within 3 years from the date of death, which saved the petitioner, as the right to apply for administration was taken to commence when the previous petition for grant filed by another person was withdrawn more than 3 years from the date of death, and a fresh petition was also consequently filed for more than 3 years from the date of death. The date of death was not reckoned to be the date when the right to apply accrues. The said principle was reiterated in Kishan Kumar, and it was held that any application to civil court under Act of 1925 is covered by Article 137. This is it. And in the concluding portion, my lord, their lordships held that it applies.
Where?
My lord, kindly, in the instant case, we do not find any explanation offered for not restoring the probate
Yes.
proceeding, and this long delay has not been explained.
In such circumstances.
Paragraph 41. By
Yes.
reason of the judgment of the Supreme Court, the second application could have been maintained if it were filed on or before 20th April. In any event, no explanation was offered for not restoring the probate proceeding and within the period of limitation. On this ground also, the application for grant of probate is liable to be dismissed. In this case, my lord, there is
But
nothing.
Mr. Ghosh, their contention is the contents of the will, the intent of the testator stands reflected in the objection filed. His ultimate first contention is that
No, that is with regard to execution.
yes.
As
No,
my lord, what I have heard,
What is your reply to that?
my lord,
What is your reply to
my
that?
lord, execution. Question is, my lord, execution is to be considered along with the suspicious circumstances and other things, which I have
Right.
very much stated, my lord, and that also I have given in my written note.
What is your answer to this argument?
My lord,
What is your answer to the argument that's advanced?
yes.
That please see the written objection. By reading the written objection, it cannot be construed in any manner that the will, that existence of the will has been admitted.
Existence of the will does not mean, my lord, it has been executed.
Properly executed.
It has been executed, my lord, with genuine.
But the contention are in parity with what has been stated.
No, my lord, kindly turn to my note. First note, my lord, which I have given. Kindly refer to my first note, which I have given.
Yes.
On the first day.
Yes.
My lord,
First note you have said, Mr. Ghosh, that the signature was on shaky hand, that itself has been
this is, my lord,
admitted by-
page 2 top. Page 2
What?
top.
The answer which we are seeking is
Yes.
suppose the execution in the written objection which has been filed,
Yes.
the written objection which has been, the discussion tallies with the recital of the will.
No, my lord. In this,
So,
these are the
when you
objections
add-
taken in my written objection filed.
No.
The objector being the present, we have, that is in paragraph 20 to 21. No, paragraph, my lord, in this connection, I relied upon 59 Supreme Court. 59 Supreme
Paragraph
Court categorically, page
Paragraph-
2 top.
No. Which paragraph you are saying? With this regard, 61 Calcutta. Which paragraph you are showing, Mr. Ghosh?
61, no. My lord, just above that,
The one which you have.
the
filed
objector,
today.
I have, objection, my lord, I have said that these can be regarded as a suspicious circumstances, according
Yes,
to the,
yes.
according to the Supreme Court, 1959.
That is page 2 of the
Page
first
2,
written
yes.
argument. Yes.
And actually, we have done that. We have made that objection. Then,
Yes.
but the learned judge, my lord, didn't look into that. Learned judge said, observe that since it is a 30 years old document, that
Presumption.
presumption applies. That doesn't apply. Presumption, that also, my lord, I have given judgment
Paragraph 3.
in page 3, paragraph 2.
Paragraph 2. Yes.
That
All right, Mr. Ghosh. Anything else, Mr. Ghosh?
these are the things, my lord, I have stated in detail, my lord, in the note and the judgment I have annexed. My lord, question simply, last point, my lord, I have modified
Limitation.
Yes.
the previous.
About that limitation.
Limitation.
Yes. No.
No, sorry. I have 2 widows.
Yes.
I have also relied on that judgment. This is
No. You have not relied upon anything with regard to this point.
no. Eta na. Again.
My lord, since it is, my contention is, my lord, since it is barred by limitation,
Oh.
since it is barred by limitation,
Nothing can be.
then, my lord, the other question, my lord,
No.
does not arise.
That's true. If it is barred by limitation, no question can
That
be
is
looked
your primary argument.
Yes.
Barred by limitation, as such, we need not go into
to any other question.
Mr. Basu.
Not only that, my lord, that
Advocate for the
if it is barred by limitation, my lord, the succession opens. The will has not been provided. The succession opens then and there. It cannot, my lord, wait, my lord, for the,
in great details.
that I have stated in, and that for that, my lord, I have relied upon one judgment of the which has been given. Hmm? Yes, sir. Down.
সাকসেশন হবে यार বলার
আজকে দিলেন তো
Yes.
তো পাইনি ওটা
We have kept it, we have orders on 12th of November after the vacation.
My lord?
Any clarification?
My lord,
12 November 12 November
12th.
12th of November.
November
বললো জাজমেন্ট যাচ্ছে
Hmm?
কালকে দিয়ে দেবেন কালকে দিয়ে দেবে জাজমেন্টটা
my lord, one judgment, my lord, we shall have to,
Of course, we have not reserved the judgment. We have considered your arguments, we kept it as orders so that we can.
my lord, in the last, today, the note which I have filed, I have referred to one judgment,
2008.
2008 yes
2008.
Yeah, 2008.
That has not been given to your lordship, my lord, that will be supplied.
no
No, that has not been given.
not supplied
আচ্ছা এটা করে রিজার্ভ
1467
I have just given the reference.
চিনি না
আজকে দিল পেন্সিলটা কি বলছি এখানে কথাটা কি বলছেন
may I take one leap? The judgment of the division bench of a Lord's Court has been cited today itself. I have not gone in through it. My lord is.
My lord, I have
nothing
given
me.
the note, my lord,
My
before
fault.
that.
This is my fault, sir. My fault.
Long back, my lord. I have-
My fault. If my lord, if necessary, my lord, equivalent. Lordship is keeping on for orders.
এই 12
My lord is not making CAV. My lord is keeping for orders. If necessary, give me 1 minute.
2 p.m. 2 p.m.
Yeah, তুমি check করো। আমি এগুলো দিয়ে
On that day, judgment was, supplied the judgment or tomorrow, just now,
ঠিক?
2008.
এখন তো দিয়ে দিয়েছে তো।
না 2008 যেটা সকালে আজকে রেফার
ও।
করেছে।
Citation দিয়ে দিয়েছে।
You have given the citation, we shall go through.
No, oh, site, oh, I'm sorry.
Citation.
No, sir,
Not
postpone উঠে যাবে।
slide,
Yes, yes. AIR citation, my lord. I have given it.
Better. Can you tell us the paragraphs?
paragraph,
The year 2008 paragraphs, can you tell us?
not,
No, it
me,
is
my lord,
not
supply.
with me.
Not with me.
Xerox it, mark out the paragraphs and hand it over to our court officer.
দিয়ে দিও।
Yes, I'm the,
And number of the matter, please.
yes. এটা
চল না রে।
আমি ঠিক করে,
তুমি brief লিখ না।
না আজকে
আমার কাছে
ফর অর্ডারসে থাকবে, এই ফর অর্ডারসে
বাড়িতে অত এই নেই, জায়গা নেই।
Thank you.
না, ওরা mention করে দেখুন TV আর ওখানে। ভাবলাম mention করবেন।
কি হয়েছে? Any problem?
No, I thought they were standing for. I thought you wanted to mention. I also thought she wanted to mention.
My lord wants to be troubled, but he is not troubling, my lord.